And this lawsuit was commenced in late 1988, and the plaintiff in this case was an assistant district attorney in Dutchess County by the name of Stephen A. Pagonis. And the defendants in the case that he named were Alton Maddox, C. Vernon Mason, Alfred C. Shopton, and Tawana Brawley. Now, Tawana Brawley was at that time only 16 years of age. She was still a minor. And there is a technical defect in the pleadings because she was sued as an adult and not a minor. And therefore, this claim against her is bogus. Now, as you know, at the end of this case, the judge is supposed to hold what is called an inquest. And he would basically put Pagonis on the stand and go down the elements of the complaint that relates to Tawana Brawley and have him to give testimony about those elements. And then in addition to that, he would bring in a process server to prove that she was properly served. The problem they have, though, again, is that Tawana Brawley was a minor and that no guardian was named in the complaint itself, and therefore there can be no judgment against her. And even if New York chooses to ignore that fact, Tawana Brawley no longer resides in the New York City area. She resides in the Washington, D.C. area. And in order for that judgment to be enforced in D.C., it would have to satisfy the full and faith and credit clause of the United States Constitution. And among those things, it would have to, the plaintiff would have to demonstrate that this judgment was obtained in accordance with due process of law, which it could not prove. And therefore, this whole matter against Tawana Brawley is in fact an exercise in futility. Now, by Mr. Pagonis being an assistant district attorney, he's also a public official. And as a public official, he has a much higher burden of proof. And actually, in most instances, even if a public official wins a judgment at trial, the appellate courts reverse it because the burden of proof is so heavy that very few public officials have ever been able to sustain that burden of proof. In the garden variety libel cases, defamation cases, if you will, more than 50% of those judgments are reversed on appeal. So when you look at a case of this sort, it is very difficult to prove. It is definitely very difficult to sustain. Now, Mr. Pagonis is a public official because of a case called New York Times versus Sullivan. And this is one of those cases that certainly should be in the background of history of Africans in America, because it goes back to the early 60s. It arises out of a judgment in Alabama in which the police commissioner at that time in Montgomery, Alabama, sued a number of clergy. Most prominently mentioned was obviously Dr. King, and also sued the New York Times for transmitting the statements that Dr. King made. And in Alabama, they obtained a judgment against Dr. King. They found that Dr. King had in fact made certain false statements against the police commissioner of Montgomery. The case went up on appeal. New York Times was one of the appellants. Dr. King also was one of the appellants. There were other members of the clergy who also were part of that process. And certainly the right there was the right to speak freely and speak openly, which is a fundamental right. The New York Times obviously had an interest in terms of having a free press that could make fair comment on cases without fear of being unnecessarily sued on. And as a result of that, the United States Supreme Court reversed the judgment in the Alabama court and ruled that although some of the statements that Dr. King and others had made were indeed false, that was not enough. There was a burden on the police commissioner to prove that those statements were made knowingly false, or that there was a truth that existed at the time that the statement was made. and that Dr. King and others had a utter disregard for the truth. In other words, they knew what the truth of the statements were, but they disregarded the truth and made the statements anyway. Now, that's a backdrop against which this case has been initiated in terms of the burden of proof that Stephen Pagonis has to sustain. Now, when you look at the litigation itself, you know, one of the media cries was, "Why don't Tawana talk?" And we picked up on it in our community. Everybody started parroting the media. Why don't Tawana talk? People had no idea why they were saying that, not knowing that a defamation action has different interests than a rape prosecution. And as I think I indicated much earlier in this interview, the fact of the matter is that we were dealing with statements that Tawana could not have helped us on. Statements, for example, that I'm being brought up on, the two statements I'm being brought up on now, for example, is one statement where I said Mr. Grady knew that one of his assistant district attorneys was involved in the abuse of Tawana Brawley. The jury found that that was defamatory. However, the essence of that statement is a cover-up. Tawana Brawley would have no knowledge as to that particular statement. She couldn't help me if she came in, because that statement does not relate to the 4 days that Tawana Brawley was missing in November of 1987. That statement relates to the post-finding of Tawana Brawley, the conduct of William Grady when he first started this case, William Grady being the district attorney of Dutchess County, and his knowledge, or his should have known knowledge, that Stephen Pagonis was somehow involved in this case, and he should have gotten out of the case. Well, that had nothing to do with Tawana Brawley. What could Tawana Brawley come in here and testify on a cover-up? Nothing. So there's no reason for her to be here. You see, but the media don't explain that to our community. And our community, unfortunately, is at the beck and call of white media, since we don't really have a real strong black media in our community. The second statement I made was that the death of Harry Chris was not a suicide, it was a murder. Now, what would Tawana Brawley have to say on that statement? Absolutely nothing. She couldn't help me at all. So, you know, for those people who say, well, Tawana has let him down, Tawana hasn't let me down because Tawana wasn't relevant to those statements. We're not talking about the conduct of Stephen Pagonis. We're talking about the statements of Alton Maddox. The conduct of Stephen Pagonis is a relevant issue in a rape prosecution. In that kind of prosecution, Tawana would come in and say Stephen Pagonis did it. That would be relevant. In a defamation action, you're dealing with the statements of Alton Maddox, many of those statements that have nothing to do with Tawana Brawley at all.